Question number 201. Which section of IPC deals with those conditions when consent is said to be not free consent? Correct answer is section 90. Question number 202. In which section of IPC the words good faith has not been used? Options are section 90, section 89, section 92, section 93. Correct answer is A, section 90. In section 90, the word good faith had not been used. Question number 203. Under IPC, the defense of consent is not available in the cases of A, consent to cause death, consent to cause grievous hurt, both A and B, none of the above. Correct answer is option C, that is both A and B, consent to cause death and consent to cause grievous hurt. Question number 204. In which of the following cases consent is free consent? Option A, consent given by a person under fear of injury, consent given by an intoxicated person, consent given under misconception of fact, consent given by a child who is above 12 but below 14 years of age. Correct answer is option D, that is consent given by a child who is above 12 but below 14 years of age. Question number 205. The object of section 92 of IPC is the protection of medical practitioners, the protection of legal practitioners, the protection of intoxicated persons, all of the above. Correct answer is the protection of medical practitioners. Question number 206. Zad is carried off by a tiger. A fires at the tiger knowing it to be likely that the shot may kill Z, but he does it in good faith, intending to save Z. A's bullet gives Z a mortal wound. Which one of the following statement is correct? A will be held guilty of culpable homicide not amounting to murder. A can take the defense under section 92 of the Penal Code dealing with the acts done without consent. C, A can plead accident. D, none of the above is correct. Here the correct answer is option B, that is A can take the defense of section 92 of the Indian Penal Code dealing with the acts done without consent. Question number 207. A is in a house which is on fire with Z, a child. People below hold out a blanket. A's drop the child from the house top, knowing it to be likely that the fall may kill the child, but not intending to kill the child and intending in good faith for the child's benefit, and the child dies. Which of the following offence has been committed by A? Option A, section 304A of IPC, section 304 part 2nd of IPC, section 302 of IPC. A has committed no offence. Here the correct answer is option D, that is A has committed no offence. Question number 208. A surgeon sees a child suffer an accident which is likely to prove fatal unless an operation be immediately performed. There is no time to apply the child's guardian. A performs the operation in spite of the entreaties of the child in good faith for the child's benefit. The child died. A has committed option A, culpable homicide, option B, murder, C, attempt to murder, D, no offence. Here the correct answer is option D, that is no offence. Question number 209. A surgeon in good faith communicates to a patient his opinion that the patient cannot live. The patient dies in consequence of the shock. A is guilty of murder, causing death by negligence, culpable homicide not amounting to murder, no offence. Correct answer is option D, that is no offence. Act causing slight harm is an offence, no offence. No offence if that harm is so slight that no person of ordinary sense and temper would complain of such harm, none of the above. Correct answer is option C, that is no offence if that harm is so slight that no person of ordinary sense and temper would complain of such harm. Question number 211. The maxim de minimis non curate lex is related to which of the following sections of IPC? Correct answer is section 95. Question number 212. The maxim de minimis non curate lex is the foundation of which general exception under chapter 4 of IPC? Option A, act of causing slight harm. This is the correct answer, act of causing slight harm. Question number 213. Which of the following conclusions can be drawn from the maxim de minimis non curate lex? Option A, necessity knows no law. Option B, nothing is an offence done by a child under 7 years of age. Option C, every person is liable for his own acts. And option D, trifling acts do not constitute an offence. Correct answer is option D, that is trifling acts do not constitute an offence. Question number 214. The rule de minimis non curate lex means that trivial discrepancies must not be overlooked. Trivial discrepancies must be overlooked. Significant discrepancies must be overlooked. Significant discrepancies must not be overlooked. Here the correct answer is option B, that is trivial discrepancies must be overlooked. Question number 215. A blacksmith is seized by a gang of dacoits and forced by threat of instant death to take his tools and to force the door of B's house. The dacoits, 10 in number, loots B's money and jewels and kills B's son A. Option A is guilty of dacoity with murder, is guilty of housebreaking and abetment of dacoity, is not guilty of any offence, is guilty of making preparation to commit dacoity. Here the correct answer is option C, that is not guilty of any offence. Question number 216. X voluntarily joins a gang of dacoits. The head of the gang order X to kill Y, otherwise X would be killed. X kills Y in order to save his life. Which one of the following statement is correct with regard to the liability of X? Option A. X is not liable because the act was done in pursuance to the order given by the superior. X is not liable because the act done under the threat. Option C. X is liable because when a person joins a gang voluntarily knowing the character of the gang, then threat cannot be a defense. Option D. X is liable because in no case to save his own life he can take the life of others. Correct answer is option C, that is X is liable because when a person joins a gang voluntarily knows the character of the gang, then threat cannot be a defense. Question number 217. Nothing is an offense which is done in exercise of the right of private defense. Where the aid of the society cannot be obtained, individual may do everything necessary to protect himself. Options: both A and R are true and R is the correct explanation of A. Both A and R are true but R is not the correct explanation of A. A is true but R is false. A is false but R is true. Here the correct answer is option B, that is both A and R are true but R is not the correct explanation of A. Question number 218. The right of private defense is based on the natural instinct of self-respect, self-protection, self-reliance, self-sufficiency. Correct answer is self-protection. Question number 219. Every person has the right to private defense. A. His own body and property, his own body and property and the body of any other person, his own body and property and the body and property of any other person. Correct answer is option D, that is his own body and property and the body and property of any other person. Question number 220. The right of private defense is not a right of defense but of retribution. Is a right of defense but not right of retribution. Is a right of defense as well as the right of retribution. Is neither a right of defense nor a right of retribution. Here the correct answer is option B, that is a right of defense but not a right of retribution. Question number 221. Right of private defense is available to all irrespective of gender and age of person except police officer, officers of armed forces, aggressors, officers of BSF. Correct answer is aggressors. Question number 222. Section 97 of IPC expressly states that the right of private defense is subject to the restrictions contained in Section 99, Section 100, Section 98, Section 102. Correct answer is option A, that is Section 99 of IPC. Question number 223. Right of private defense is available against all members of an unlawful assembly in a free fight to retrieve from the wrongdoer's one property, both A and B and above. Correct answer is option A, that is against all members of an unlawful assembly. Question number 224. In which of the following cases Supreme Court has observed that there is no right of private defense against the right of private defense? Options are State of Punjab versus Sohan Singh, Surjit Singh versus State of Punjab, State of UP versus Ram Swarup, MR Singh versus State of Gujarat. Here the correct answer is option C, that is State of UP versus Ram Swarup. Question number 225. Right of private defense is not available against an insane, against a child, when there is a time to recourse the public authorities, all of the above. Correct answer is option C, that is when there is a time to recourse the public authorities.